Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 3 and 4 on the speed of 90 words per minute. Start. The record revealed that the state government was seized with the issue as to whether, after the order of the hearing authority dated 25/4/2008, publication of the modified scheme was required as per law or not, but no final decision could be taken in this regard, and ultimately, as per the note sheet dated 31/5/2013, the state government proposed to cancel or withdraw the proposal for modification of the scheme dated 5/8/2005, but no final decision could be taken even on this issue, and the matter remained pending awaiting the opinion of the legal remembrancer in the matter. In view of the above discussion, this court is of the view that in the absence of any decision of the state government approving the modified scheme dated 5/8/2005 as envisaged under section 1021 of the Act 1988, as per the dictum in Rashid Javed's case supra, the route in question continues to be a notified nationalized route in respect of which the state transport undertaking and the persons mentioned in the notified scheme or persons legally entitled to ply as successor in interest alone are entitled to ply. It being so, the rejection of the application of the opposite parties for grant of permit on the said route on the ground of it being a nationalized route did not suffer from any error, and it would not be amenable to an appeal under section 89 of the Act 1988. It being so, the very basis for rejection of the application for impleadment filed by the petitioner herein by the appellate authority as also denying him a right of hearing falls to the ground. The remedy, if any, was by way of a revision under section 90 of the Act 1988, and under the proviso to section 90, no order could be passed in such revision unless the person who would be prejudiced by such order or given a reasonable opportunity of being heard. Had the private opposite parties filed such a revision, the revisional court would have considered the question of locus standi in the light of the aforesaid proviso. Suffice it to say that a specific assertion has been made in the paragraph 4 of the writ petition that the applicants and their predecessors in interest were permitted to ply the vehicle on the route in question as per the scheme notified, which has not been specifically and categorically denied either by the private opposite party or by the state in their counter affidavit. In fact, it has been admitted in the counter affidavit that the petitioner is plying on the route in question. During the course of the argument, Shree Saxena himself stated that the petitioner was plying on the route in question in terms of some interim order passed by the revisional authority. Had it been a non-notified route, then the plea of the opposite parties as regards locus standi may have carried weight in view of the authorities cited by them, but it being a notified route, it cannot be said that he does not have any locus standi to maintain this petition. Sri Ashok Kari, Senior Advocate, assisted by Sri J.P. Singh, Advocate, submitted that in the present case, learned single judge has transgressed and overstepped his jurisdiction at the point of time when he has proceeded to allow the writ petition, and to substantiate this fact it has been sought to be contended that in spite of the fact that Parliamentary Act, namely Act number 2 of 2005, was not even under challenge as amended by Act number 18 of 2006, the same has been in effect altered. In view of this, the appeal in question deserves to be allowed, and especially in the peculiar backdrop of the case that Dr. Madan Kumar Bansal has no concern with the society and the institution. The request that has been made on behalf of the appellant has been resisted by the learned standing counsel as well as Sri Indraraj Singh, Advocate, along with Sri Prabhakar Avasthi, Advocate, by submitting that at no point of time the institution in question has been established by the members of the minority community, and on totally wrong facts the institution in question has been declared as minority institution, and this court has rightly allowed the writ petition, and petitioner Dr. Madan Kumar Bansal has full locus to assail the validity of the action so taken. Before proceeding to consider the respective arguments that have been so advanced, the issue of locus is being taken up first. The petitioner in the body of writ petition made a categorical mention of fact that petitioner is a life member of the general body. In the counter affidavit that has been so filed, a mention has been made that membership of petitioner has been dispensed with and he has no concern. The resolution that has been relied upon also accepts this fact that petitioner is life member of general body and he has been removed as he and his group has been indulging in anti-institutional activities. Petitioner in his turn has come up with the specific case that entire proceedings have been manufactured only for the purposes of case. Once such are the allegations coming forward, coupled with the fact that the petitioner in the rejoinder affidavit that has been so filed has come up with the specific case that his grandfather made a contribution of rupees 11,000 in the year 1948, and the most surprising feature of the writ petition is that in the memorandum that has been so prepared, therein the name of petitioner's grandfather has been mentioned. Once such is the factual situation that petitioner has been a member of the general body, and now it is being contended that he has been thrown out of membership, and same is being disputed by him and his grandfather, and others have contributed along with the public of Billari for the establishment of the institution in question, then certainly petitioner has a locus to question the validity of the decision that has been so taken, declaring the institution in question to be a minority institution.